All right, the next case we have on the docket is 250702, Gary Ewers, individual and as co-trustee, et cetera, versus Ronald Ewers as co-trustee, et cetera. And there's a cross appeal, so both sides let me know how much you want to reserve for rebuttal, and we'll go forward.
Thank you, Your Honor. Good afternoon. May it please the court. Joe Eagleton with Brannick Berman and Sider for the appellants, Gary Ewers and Bradley Ewers. If I could, Judge Edwards, I'd like to reserve 5 minutes of my time for rebuttal. Thank you. So the trial court was dealing with a lot of issues in this years-long litigation over a family trust, and in our view, got a lot of those issues correct. There was a 2-week bench trial, and we're asking this court simply to correct what we believe are two pretty straightforward legal errors the trial court made in interpreting the trust. I hope to have time to address both of those. I'd like to start with the trial court's interpretation of what we've called the self-dealing clause. And so when Phyllis Ewers established her trust, and this was part of a joint estate plan that was designed for 3 purposes, the trial court found this at page 11 of the amended judgment, to reduce taxes, to provide for the needs of the surviving spouse, who was Ronald, and to pass assets on to Phyllis's children and grandchildren. She had the foresight to do something that most trust settlers don't do. She gave her oldest son, Brad, the power to amend her trust after she was gone and to protect its assets. The text of the trust provides a few different things Brad can do in exercising his power. He can correct ambiguities. He can amend the technical and administrative provisions of the trust to ensure favorable tax treatment. And further, the trust says, he can amend the trust to ensure that Phyllis's intentions and desires are carried out. This is a broad power, and it's one that, as the Maniason case explains, the trust settler chose as her preferred method for resolving issues that might arise about what she wanted from her trust. And so here, Brad exercised the power granted to him from the text of the trust in a way the trial court found appropriate and in good faith. He amended the trust to protect it and to protect the joint estate plan and to protect the surviving spouse, Ron, from having assets of the trust used by a third person who came into the picture after Phyllis passed away. The amendment also had the effect of ensuring that the beneficiaries and the family would be protected in the long run while honoring Phyllis's intent to provide and support for Ron during his lifetime by allowing him to access any funds that he needs, because Ron had gone about disinheriting the family in favor of his new wife, Elizabeth. The trial court accepted all of this as a factual matter and again found that this amendment to the trust furthered Phyllis's intentions and desires. That should have resolved the case because Brad properly exercised his power, and doing so was consistent with the text of the trust and with Phyllis's intentions and desires as they were found. So why are we here? Well, we're here because despite doing all of that, the trial court still invalidated the amendment under its erroneous reading of the self-dealing clause. That's a provision that says Brad cannot directly or indirectly benefit from the amendment. And that interpretation we think was wrong for a few reasons, as we've explained in the briefs, but I want to focus on 2 of them today. The first is that Brad did not benefit from this amendment. He did not receive money from it, nor any other advantage from making this amendment. The amendment was not about Brad at all. The amendment just protected the trust. Sure, ultimately protecting the trust helps all of the beneficiaries, but only in so much as amending the trust to ensure favorable tax treatment, for example, which is something everyone agrees Brad has the power to do, would help all of the beneficiaries. He got nothing from this amendment. He has never received money from this trust. He may never receive money from this trust. So there simply was no benefit to Brad from this amendment. That is enough, standing alone, I think, to overturn the trial court's reading of this clause. But in addition to that, I think the provisions of the trust under established law must be read in context and as a harmonious whole to accomplish the goals of the trust. And so when we have the trust protector acting in good faith in a manner that furthers the intentions and desires of the settler, as the trial court found, reading the self-dealing clause then to invalidate the trust protector's actions makes no sense and cannot be the correct interpretation. To effectuate both provisions, which can be done, simply requires reading the self-dealing clause to prohibit the trust protector from gaining any advantage over the other beneficiaries through the exercise of his powers. You know, a benefit is by definition an advantage, and so Brad is prohibited certainly from amending the trust to gain an advantage. He is not prohibited from using his power in a way that benefits the trust and the beneficiaries as a class, which is all the First Amendment to the trust did. So,
With regard to the self-dealing provision there, aren't all beneficiaries or potential beneficiaries of the Phyllis Trust family members of Brad's?
yes, Your Honor.
I mean, I guess somebody else could be appointed as trust protector who would be outside the family.
That's right, Your Honor. But all the beneficiaries, it's a family trust, and so all of the beneficiaries are family members. So that's essentially our position, Your Honor, which is anything Brad does he has a fiduciary responsibility to the beneficiaries of this trust. All the beneficiaries of the trust are Brad's family members. So in essence, what we think the trial court has done here through its interpretation of self-dealing clause is essentially render his power more or less meaningless to amend the trust. And
Of course, your opponents take the position that that First Amendment was not valid, should not have been upheld.
right, Your
Okay.
Honor. That's right, Your Honor. Although,
If you want to wait and take that up and rebuttal, that's fine, see if they raise it, but I'm pretty sure they might. So I don't know if you want to touch on that now, or you want to just catch it in your last 5 minutes. Up to you.
Sure, Your Honor. I'd be happy to talk about that a little bit. I think, it seems to me that their argument really hinges a lot on viewing the trial court as considering, parole evidence. I think that, though, is a misunderstanding of what the trial court did in the context of this trust and the facts of this case. So certainly it's well established that, in the ordinary trust interpretation case, we look at the sort of four corners of the trust documents, we discern the settler's intent from what's in the text of the trust. Well, the trial court did that because the text of the trust here says something most trusts don't. It says, I want my son Brad to have the power to amend this trust to ensure that my intentions and desires are carried out. And so, in our view, that's the provision the trial court was relying on. The trial court was correct in looking at the terms of the trust and saying, here we have a person who I'm trying to effectuate her intent, and what she's told me her intent is for Brad to be able to ensure that her intentions and desires are being carried out. And then the trial court went about...
Isn't that seems a little circular to me.
Well, I think it's giving effect to the text of the trust, Your Honor.
Circular is problematic, though, right? Circular makes it very difficult for judges to interpret, for the trust protector to interpret. Trust protector, as I read the language, had to determine what the desires were, what the intent and desires were, correct?
I think that's right, Your Honor.
So how do we do that?
Well, I think that the trust protector has the fiduciary responsibility to do that under the terms of the trust. And so necessarily then it required the trial court to take some evidence of what were her desires and what did the trust protector do to understand what those desires were, what did the trust protector think those desires were, and did the trust protector act in good faith and consistent?
So you think that going outside the four corners was appropriate?
Yes, Your Honor.
Determine intent and desire.
To determine intentions and desires, yes, Your Honor. I think that it necessarily required the consideration of evidence, and I think that therefore when
Why couldn't it just be the four corners of the document? I mean, there's a lot of intent and a lot of desires communicated within the four corners, right?
it may be the case that it's possible that her intentions and desires could be clear under some circumstances for, what was intended. But I think, again, the trial court heard all of this and decided that this amendment was consistent with her intentions and desires and what she would have wanted. I mean, this is a situation where essentially something unforeseen, perhaps, to her came up after after she passed away, in the sense that when this was a joint estate plan that was put into place, it was always considered, and the trial court found that one of the purposes here was, yes, to provide for the needs of the surviving spouse, but also to pass on the estate to the children and to the grandchildren. And the trial court also found that Ronald was not acting in the best interests of the family or of the trust. This is at page 13, 920 to 21 of the record. The trial court said Ronald was, quote, not abiding by the estate plan of or the intentions and desires of Phyllis Ewers. And so I think based on that finding,
Where is there anything that says in the original trust documents that Ron had to demonstrate need to get the 5 or 5 provisions? And that turns out to be a lot of money.
Yes, Your Honor. So our position has always been that 5 or 5 withdrawal is part of an article dealing with distributions, and that all distributions from the trust were subject to what's called the HEMS standard. And so that was always the position of my clients. But, to the extent that there was some ambiguity then in whether he needed to show need or not show need, then again, Phyllis Ewers provided that the way to correct any ambiguity was for the trust protector to have the ability to clarify that ambiguity through an amendment.
It doesn't say anything about necessity in the trust. How does that become ambiguous that maybe he does need to show necessity or need?
Well, so first of all, again, I think this was part of the same article of the trust, and so it was our position that under that article of the trust, all distributions were required a showing of need. And so otherwise, the trust was not fully taking advantage of tax savings. But again, the provision that Brad relied on I don't think that, Your Honor, is really the issue here. The issue is whether the First Amendment to the trust was a valid exercise of the trust protector's power. The trust protector has the power under the text of the trust to amend the trust to ensure that the grantor's intentions and desires are being carried out. And so based on the facts of this case and the context that was going on at the time this amendment was made, it was a proper exercise of his power to ensure that money was not being taken out of this trust to go to the benefit of someone other than the family of Phyllis Ewers, someone who was not Phyllis Ewers never knew at the time she was making her trust, to use money that was no longer furthering the joint estate plan that was the very purpose
I
for this.
can understand the concept and why Brad did that, but in terms of finding the intents and desires, anything other than Brad basically going, Mom would never have wanted this. I mean, that's okay. Brad can just go, Mom would never have wanted this to go this way. We need to change this. And that's enough?
I think, Your Honor, when the trust says he has the power to amend the trust to ensure that her intentions and desires, the trial court spent a lot of time talking about what desires mean. This is not just a case about the sort of legal term of art, settler's intent. This is a woman putting the phrase intentions and desires being carried out in her trust. Yes, I think she entrusted her son to make that determination. And again, there was lots of evidence that was heard about this and considered about this, and the trial court made a factual finding that this was consistent with, her intentions and desires, the amendment that he made in this case.
All right. Go on to whatever else you want to. It's your time.
Well, I do want to touch briefly, before I get into my rebuttal, just on the second interpretive error that we've raised regarding the incapacity determination that was made by the trustee. And so like the broad power granted to Brad as trust protector, the text of the trust similarly grants some broad powers to Gary, who's the trustee. And one of those powers is to declare a beneficiary incapacitated in his, quote, absolute and uncontrolled discretion. And the trust actually says the beneficiary, quote, shall be deemed incapacitated if the trustee makes that determination. And that's what happened here. And it wasn't some flippant thing, This was done completely by the book, supported by a list of 15 reasons, which we've detailed in the briefs.
But wasn't it, excuse me, counsel, but wasn't it that discretion bounded by a physical or mental condition?
Yes, Your Honor.
Okay.
And so, but I think it did not, unlike, say, removing a trustee, removing a beneficiary did not require, a diagnosis. It simply said a mental or physical condition.
Well, but wasn't the testimony that he hadn't had contact with him, he wasn't aware of conditions, condition diagnosis, disagreement with decision-making is different than a mental or physical condition, is it not?
Well, I think, Your Honor, it was more than just disagreement with decision-making. It was the inability to recall important financial decisions. So memory issues, I think, are a mental condition. It was the sudden withdrawal from all relationships, not just obviously the family acrimony that was going on, but longtime friends and people who were pillars of the community that he'd been involved in for a long time. So there were 15 reasons, I think, that were much more than just, we disagree about things here. And again, I think if we're sort of parsing the reasons, then we've already sort of overstepped what the role of the court was here. The role of the court is to simply understand whether Gary's exercising his absolute and uncontrolled discretion in good faith, consistent with his fiduciary responsibility as trustee. And, the trial court did not find any breach of fiduciary duty, in fact, rejected claims alleging breach of fiduciary duty. So I think, as long as he exercised his discretion which he did, consistent with the text of the trust and with his fiduciary obligations, I think that's really as far as the trial court's inquiry should have gone under the governing statute. I know I'm into my rebuttal time, so unless the court has other questions, I'll reserve the rest of my time. Thank you.
I'd like to reserve 4 minutes for rebuttal, please.
4 minutes, okay.
May it please the court. My name is Jennifer Lester, and I'm here with my partner, Xander Riley. We represent Ron Ewers, the plaintiff below, the grantor's husband, and the primary beneficiary of the trust at issue in this case. We're before the court today on a number of issues, but the most important issue is the ruling below essentially takes trust interpretation in an entirely new direction. Both parties agree that the trust was unambiguous, and the parties' briefs are replete with citations to Florida law that the intent of the grantor must be determined by the language of a trust if the trust is determined to be unambiguous. Despite that, the court below ignored that principle and allowed the trust protector to amend an unambiguous trust to change its dispositive provisions to what he reasonably believed the grantor would have wanted. There simply is no precedent, and appellant has cited to none, for such a principle. There are several important facts that were omitted from the appellant's argument, so I'll address those briefly. It's important to know that while the Ewers sons attended an initial financial planning meeting with the estate planner, they did not attend any of the other drafting meetings to draft the Phyllis Trust. Bradley, the trust protector, testified that he never discussed the specifics of the trust with his mother, and that he never discussed the application of the dispositive provisions with her. The family trust was the only trust that was funded due to changes in estate tax law, and it states very clearly in Section A that the trust is to be for the primary benefit of Ron. Her intent is clear. She intends the trust to first benefit her husband and then to be passed down to her children. It provided for Ron in two ways, both limited. Under Section B, it provided that any amount could be used for his health, education, maintenance, and support based on need. And the second way is limited by amount. He was entitled under estate tax law at the time to take either 5% or $5,000 of the trust principal at his election. And this was not considered a distribution. This is called a right of withdrawal. This is a common estate tax planning provision, and it is meant to give the spouse of a decedent some flexibility to obtain funds without having to demonstrate need to a trustee. When Ron remarried against his son's wishes, the trust protector amended the trust to change the language in Section 4C so that Ron no longer had the right to withdraw 5%, but that right was limited by the HEM standard contained in subsection B. This clearly was not the intent of the grantor, and the court did not, find that provision of the trust was ambiguous in any way. The power of the trust protector to make changes to the trust is listed in Section 5, the first section, which states, the power to modify or amend the administrative and technical provisions of this trust agreement to achieve favorable tax status or respond to changes in the code and state law or the rulings and regulations thereunder, and further amend this agreement to ensure that the grantor's intentions and desires are carried out. Then Section 2 relates the power to remove a trustee, but not to replace a trustee. 3 is the power to correct ambiguities. And 4 is to release powers under the trust protector powers, but he was not able to increase the powers. The subsection that the court and the appellants relied on is subsection 1, which specifically relates to modifying the trust to address changes in tax law, and that is the only section that references an ability for the trust protector to make changes based on the grantor's intents and desires. Once the trust was determined to be unambiguous, the court should not have proceeded farther. But in its ruling, at page 13,910 of the record, the court explains that once the plaintiff, which was Ron, showed that the trust was unambiguous, the burden then shifted to the appellants to show not what the grantor's intent was. The court prohibited the introduction of evidence as to the grantor's intent, but what the trust protector reasonably believed that intent to be. Bradley, the trust protector, then testified that he knew his mother, they were close, and that he reasonably believed that given the change in circumstances, Ron marrying a woman that they did not like, she would have wanted him to amend the 505 provision to prohibit him from obtaining any funds from the trust. And so that's what he did. That evidence was irrebuttable. There is not a way for any beneficiary or co-trustee to refute the evidence that Bradley testified that he reasonably believed he knew what his mother would have wanted. There is no power in the trust for him to amend its provisions based on his reasonable beliefs, and no power in the trust code for him to do so.
I have a question, though, about in that clause, the first half talks about power to amend for favorable tax status, changes in the tax code, and so forth. If you put a period there, I think your argument makes a lot of sense, but I don't understand when you look at the next phrase, and further to amend this trust agreement to ensure that the grantor's intentions and desires are carried out. How is that limited to tax law? I'm not following that part of your argument.
Because that phrase, to ensure that the grantor's intentions and desires are carried out, is not contained in the preceding paragraph, which broadly describes the trust protector, nor is it reiterated in any of the following 3 powers given to the trust protector. Rule of construction simply dictates that that phrase modifies the list of reasons why the trust protector might modify the trust in the absence of an ambiguity. So the doctrine that we have cited to the court is...
Rule of construction are you referring to?
The rule of construction that we have referred to is justum generis, which provides that when a general phrase follows a more specific list, that the general phrase is deemed to relate to items included within that specific list. In this case, the modification would relate to any changes in law, estate tax changes, income tax changes, intangible tax changes, but not to change the dispositive provisions of the trust. And that is reflected in the limitations placed on the trust protector as well. They've argued that the limitations placed on the trust protector should not apply to Bradley because he was her son. But Phyllis knew that. She appointed Bradley in the very same document that placed a restriction on him from changing the trust in a way that would benefit him or his family members. That's a very clear demonstration of Phyllis's intent, that she did not intend the trust protector to have the ability to change the dispositive provisions of her trust. The court should have, once determined that the trust was unambiguous, stopped the introduction of evidence as to what the trust protector reasonably believed and relied on the very plain language in her trust, which dictated quite clearly that he was not to make dispositive changes to her trust, and that he was bound by his fiduciary duty to carry out her intent as to what he was able to do and what he was not. He agreed that the trust was not ambiguous, although there's some argument that was made that he made these modifications under subsection 3 of the trust protector's powers that he could correct the trust for ambiguities. There was no real argument between the parties that the trust was ambiguous, so that did not.
I guess one concern I have, and I think that the argument you've just articulated is one of the better arguments. I was not sure that you raised that argument in your cross appeal. I sort of was struggling with it to try to figure out exactly if that was the argument you were making. But one thing that your brief doesn't go into is just that how does it work if we adopt opposing counsel's view that this is sort of a subjective, whatever, forgive me, is it Brad? It's Brad, right?
Yes, sir.
Whatever Brad believes she would have wanted, now Brad can make that amendment. That seems like a power to blanket rewrite the entire document. Do you think that's an overstatement?
I think that that's the argument that appellant is seeking to have you adopt, but there's no language in the trust.
No, I'm just saying the ramifications of that seems like it would be basically just tell Brad that he can rewrite the document anytime he thinks that it should be rewritten. Is that the ultimate ramification for if we were to adopt opposing counsel's view?
Yes, and that is.
I just can't see any place where it stops.
I don't either.
Okay.
It turns trust law and the interpretation of a
And it
trust.
certainly doesn't, the language doesn't say that. It doesn't say anything Brad thinks my intentions or desires, right? It just says grantor's intentions and desires. It
Yes,
doesn't say
Your
what
Honor.
Brad thinks they are.
Yes,
right?
Your Honor. The
Right.
amended final judgment introduces that language for the first time. The amended final judgment at page 13,910, the court says the defendant has the burden of proof, both showing that the trust protector was aware of the grantor's intentions and desires as expressed in the trust, and there is no indication in the trust that she intended for Brad to have a complete authority to change the dispositive provisions in her trust. In fact, the limitations on his actions seem to mitigate against that. And then it says that the defendants were required to show that the trust protector reasonably believed that the intentions and the desires of the grantor were not being carried out. That voids the irrevocability of this trust. It means that a trust protector with the power to amend can completely change an unambiguous trust.
What were the reasons given for the second amendment?
The reasons for the Second Amendment were that
He was challenging the trust, right?
he brought an action initially on several grounds, the primary one of which was to void the First Amendment, which was to allow him to withdraw the 5%.
5%, yeah.
Right.
But wasn't it a broader challenge to the trust at that point that was a concern?
There were actions that were being taken by the trustee that were subject to the initial complaint, but the Second Amendment really destroyed the balance that Phyllis sought to achieve in the trust.
Did Ron bring an action to terminate the trust?
That was initially part of the complaint, which was later dropped. It seemed that the best.
Didn't the trustee use that as one of the grounds for taking Ron out as a trustee?
He did, and I think there was a misunderstanding about what would have happened if the trust were terminated. When trusts are terminated under Florida law, that the present value of the all qualified beneficiaries is determined and the trust is distributed. The trustee thought that all of the funds were to go to Ron, which is not what would have happened under Florida law.
But arguably not what Phyllis would have wanted, right? The trust terminated.
It's hard for us to say at this point whether Phyllis would have preferred the trust to be terminated and distributed or the vast majority
If
of the
we just stay in the
expenditures.
four corners, it seems unlikely that, seems like there's an argument that she wouldn't want it just terminated, right?
Correct. But Ron had taken no actions as co-trustee that violated his fiduciary duty, and in fact, that was part of the counterclaim. Counterclaim was that he had violated certain fiduciary duties as co-trustee, and the court found unequivocally that he had not done so.
Were there any other reasons for the Second Amendment other than those two because I'm not aware of any in the record, but was there another reason given for the Second Amendment?
I don't believe there were any reasons given for the Second Amendment.
Well, one was that he was trying to terminate the trust.
At the trial, the reasons given, and this was long after the Second Amendment was
Okay,
drafted.
that's what I'm talking about. At the trial, what were the reasons?
The reasons were that he was not working with Gary, that they did not want him to be able to appoint further trustees who would not work with Gary. And what the Second Amendment did was remove Ron's ability to appoint successor trustees, which was ability he alone held, and substituted that for a majority of the beneficiaries being able to appoint the co-trustees.
Essentially a shift of power.
A complete shift of power from
Essentially,
a
right.
balance between Phyllis's husband and her children to all of the power resting with her children. So there was the balance that she had hoped to achieve to have her husband and her sons work together was destroyed by the Second Amendment. And that was part of the issue. While it was alleged that Ron would not work with Gary, they had been working together as co-trustees and filing tax returns and gathering.
If we were to say that that the trial court's analysis on the Second Amendment was in error, what would the remand instruction look like? Would it just be that analysis was wrong, the subjective analysis was wrong? Redo it, or is there some other? What does remand look like?
For us, remand looks like a remand to reverse the finding that the First and Second Amendments were proper, but finding that they were improper as outside the authority of the powers granted to the trust protector, and finding that those powers, based on the plain reading and intent.
You won on the first one, didn't you?
The court held that it was a valid exercise, but it violated the prohibition against self-dealing.
So what do you have to appeal?
Should the court reverse on the self-dealing, we would still argue that the adoption of the First Amendment
Oh, I see.
violated.
I got you. I understand.
Right. So both trust amendments were outside the powers granted.
But look, in a world where we leave the First Amendment alone and affirm on that, then that issue's done, right? You don't.
Right.
Okay. Yeah.
Right. And then we would ask that the court reverse the finding that both Gary and Bradley can remain as fiduciaries over the trust and order the court to hold a hearing on the issue of attorney's fees, because the court found that all parties be responsible for their own fees, but did not find as to the defendants individually and the defendants as fiduciaries, and took no evidence on that. So that is what we would ask the court to do upon review and in issuing opinion, and I will reserve the rest of my time
Okay.
for rebuttal. Thank you.
So I would agree that it may be unconventional, right? That this trust includes a provision that allows for it to be amended. There's a lot of law out there, and we're all familiar with. We're looking at the text of the trust, and we're going to confine our inquiry to what did the settler intend. But, you know, Judge Eisnagel, I think that the text of this trust makes clear that this power is pretty broad. It says, and further to amend this trust agreement to ensure that the grantor's intentions and desires are carried out. So where does it end? I don't know. There's only been 2 amendments made to this trust. This trust has been in place for quite a long time.
Look, I think you're you've made a good argument. I don't know that I agree with it, but I think what it comes down to is I agree it's a broad power. Clearly it is. The question is how broad? Is it unlimited, or is it broad but limited? And I think that's the question. And I guess I just don't understand if the intention was that Brad can do anything he wants, rewrite the entire thing just because he's willing to say, I think she would have wanted this. If that is what the intent was, why isn't it said? Why doesn't the language say that?
Well,
Whatever he subjectively thinks my intentions or desires, right? Like, why is that not an objective standard?
Well, first of all, Brad's a fiduciary, right, to this trust. So his powers are constrained by his fiduciary obligations. We had years of litigation here. We had a 2-week bench trial, and we have extensive, detailed
But if the
factual
language
findings.
said that he can amend this trust agreement to ensure that the grantor's intentions and desires, as he subjectively determines them to be, are carried out,
Well, I don't think
then you would win, right? You would win. The trial court's analysis would have been correct, and frankly, then there would be no limits to his power. He'd be able to rewrite the entire thing, and that would have been the intention. But that's not what it says. It doesn't say subjectively. So why isn't it an objective? Why aren't the grantor's intentions and desires? Why is that not an objective standard as opposed to subjective?
I'm not sure, Judge Eisnagel, that it matters which standard it is here. The trial court found that this amendment was consistent with her intentions and desires. It is really not disputed that one of her main desires and intentions in this trust was to provide for the family, to provide for and pass the assets on to the family. We have a situation where the surviving spouse has gone about disinheriting the family. I mean, it's almost like we're talking in a pejorative sense about what Brad understood her intentions to be or what her intentions were to be. This was her trust. She said right in her trust, I want my son to decide and be able to carry out what my intentions and desires were. We had a 2-week trial where the trial court made extensive factual findings that said this amendment is consistent with what Phyllis Ewers wanted.
And were
what
those
she
based
desired.
upon the four corners, or were they based upon
They were based on
testimony about what people said that she wanted?
Well, they were based on lots of things, Judge Eisnagel. They were based on both, I would say.
It does seem like they were based on a lot of
They were
things.
based on both, and both sides had a fair opportunity to present their evidence of what Phyllis Ewers intended and desired, and the trial court thought the better view of that evidence of what she intended and desired was for her family to be able to have these assets passed on to them, and for this amendment to be upheld. And I think that's also consistent with the text of the trust, because the trial court also made findings about the 3 things that this trust was designed to do, and this First Amendment furthers all of those. To protect taxes, the First Amendment helps with that. To provide for the needs of the surviving spouse, nothing about the First Amendment says that the needs of the surviving spouse won't be met. It says the opposite, and it's conceded that Ron doesn't have any need for these funds. He has his own separate trust that has many millions of dollars in it. He has no need, he's admitted that, for this money. And to provide for the family, and that's why the First Amendment was made, and the trial court said that the First Amendment was consistent with what Phyllis Ewers would have wanted. I'm quickly running out of time.
Did your
so-
opposing counsel argue below that intentions and desires should only be determined based upon the 4 corners?
Yes, I think that they argued that the trial court's inquiry should be confined to the 4 corners, but I don't think that that is consistent with the text of the trust. I think that looking at the 4 corners of the trust, it is clear that Phyllis Ewers intended for the trust protector to have the power to further her
You're saying
intentions and
whether or
desires.
not even the 4 corners supports the judgment is what
That's
you're saying.
correct, Your Honor, yes. Thank you.
All right, thank you. All right, Ms. Lester?
The ruling of the lower court actually is very limited into what he was going to consider in determining whether or not the intentions and desires had been met. And it states that the defendants were required to show that the trust protector, Bradley, reasonably believed that the intentions and desires of the grantor were such that the amendment should be granted. There is no way to rebut that because all he has to do is say, I reasonably believe my mom would have wanted me to do this. There's
You
no.
try to rebut it, though, below?
We did. We attempted to offer evidence of the drafter of the trust and Ron Ewers as to the grantor's intent, and the court did not permit us to introduce any evidence as to the grantor's intent. We did
At
not.
that time or at a later time? Was it a presentation of evidence issue, or did you get a ruling on that you were not allowed to do it no matter when you tried?
We were not allowed to do it no matter when we tried. When we attempted to introduce evidence of the drafters of the trust, there was a sustained objection, and when Ron was asked to testify as to what their intent was at the time the trust was drafted, there were objections that were also sustained.
So
Let me
if the trial
address.
court looked at something other than Brad's subjective belief of Phyllis's intents and desires, if he looked at proof, people come in testifying, I heard her say this, I knew she wanted this, whatever, you think that would be appropriate in terms of setting out the objective?
Actually, I do not. I don't think anything was appropriate once the trust was found to be unambiguous other than a fair reading of the language in the trust. And the language in the trust was very clear that she intended Ron to be the primary beneficiary and for him to have both a need-based and an amount-based ability to obtain just funds from the trust, because the right of withdrawal is a bit different than a distribution, and to maintain some control over the trust by, even if he were fired as trustee, by appointing a successor trustee in his stead. There's no question that what Bradley reasonably believed Phyllis's intents and desires were. That reasonable belief is contradicted by the clear intent that she demonstrated in the trust document
Did you ever argue that reasonable belief was the wrong standard?
We argued that evidence of Phyllis's intent was the wrong standard, and that.
Right, but
that-
when the trial court said, hey, reasonable belief, Brad's reasonable belief, did you ever challenge that and say, Judge, that's the wrong standard?
We did.
Okay.
We did.
Where did you do that?
It would have, the judge was not quite as clear in his rulings
Right.
As he
Did you
was in
do
the
it on
amended final
rehearing?
judgment. We did do it in rehearing, and we argued consistently throughout that if the trust was found to be unambiguous, we wanted to present evidence as to her intent, and we were prevented from doing that.
Colleagues
you.
have any other questions? No? All right, thank you very much. Well briefed, well argued. We'll be in recess, and for the Stacy folks who may be watching us on TV, we'll get with you about 2:45. Thank you.
Thank you.